Friends, welcome back to my channel. Today I am going to discuss void agreements and voidable contracts under the Indian Contract Act 1872. So let's start. According to section 2G of the Indian Contract Act 1872, an agreement not enforceable by law is said to be void. So a void agreement is an agreement that is not enforceable by law. It is to be noted that a void agreement is void ab initio. Void ab initio means void from the beginning. A void agreement, since it is void ab initio, that is void from the beginning, so it cannot become a contract. So, since a void agreement is not enforceable by law, it does not bind the parties to the agreement. Sections 24 to 30 of the Indian Contract Act makes a specific mention of agreements which are void. So let's discuss the same. Section 24. Agreement void if consideration and objects unlawful in part. Section 24 of the Indian Contract Act goes like this. If any part of a single consideration for one or more objects, or any one or any part of any one of several considerations for a single object is unlawful, the agreement is void. So, we already know that if the considerations and objects of any agreement is unlawful, the agreement becomes void. Now, as per section 24, even if a part of the consideration or object is unlawful, the agreement becomes void. The whole agreement becomes void. It does not matter whether the whole consideration or the whole object is unlawful. Even if a part of the consideration or the part of the object is unlawful, the whole agreement becomes void. Now, if we look into the illustrations given under section 24, it says A promises to superintendent on behalf of B a legal manufacture of indigo and an illegal traffic in other articles. B promises to pay to A salary of 10,000 rupees a year. The agreement is void, the object of A's promise and the consideration of B's promise being in part unlawful. Now, if we look at this illustration, we can see that now A promises to superintendent certain work of B, which includes a legal manufacture of A, but at the same time illegal traffic of other articles, some other articles. So, though a part of the object or the consideration is lawful, we can see that a part of the object or consideration is unlawful, which includes illegal traffic in some other articles. So, the whole agreement in this case becomes void because a part of the object or the consideration is unlawful. So, even if, as per section 24, even if a part of the object or consideration is unlawful, then the whole agreement becomes void. Now, coming to section 25 of the Contract Act, agreement without consideration void unless it is in writing and registered or is a promise to compensate for something done or is a promise to pay a debt barred by limitation law. So, the first part of the section 25, we can see that the first part of the section 25 directly says that an agreement without consideration is void. So, an agreement without consideration is void, but there is an exception in it. So, it says unless it is in writing and registered or is a promise to compensate for something done or is a promise to pay a debt barred by limitation law, then under such circumstances the agreement may not be void. Now, let's read the section further. It says an agreement made without consideration is void unless, number 1, it is expressed in writing and registered under the law for the time being in force for the registration of documents and is made on account of natural love and affection between parties standing in a near relation to each other. So, let's discuss this point first. So, this first point under section 25, it says that an agreement without consideration may not be void if it is made on account of natural love and affection between the parties and they stand in a near relation to each other. So, an agreement on account of natural love and affection between parties who stands in a near relation to each other is not void even if it is without consideration, but it has to be, that means the said agreement has to be expressed in writing and registered under the law. So, the first thing is that an agreement without consideration is void, but there are certain exceptions to it. So the first exception is that an agreement without consideration is not void if the agreement is made on account of natural love and affection between the parties who stand in a near relation to each other, and that very agreement is expressed in writing and is registered under the law. This is the first exception, when the agreement without consideration is not void. Now coming to the second exception, that is, it is a promise to compensate wholly or in part a person who has already voluntarily done something for the promisor or something which the promisor was legally compellable to do. So the second exception is that an agreement without consideration is not void if the agreement is a promise to compensate wholly or in part certain person who has already voluntarily done something for the promisor. So in this circumstance also the agreement without consideration is not void. For this we can look at to the illustration C here, illustration C under section 25, which says that A finds B's purse and gives it to him. B promises to give A rupees 50. This is a contract. So here on finding B's purse, A decides to voluntarily give it to B. So since A had done certain favor to B, so B promises to give A rupees 50. So this is a contract. So this comes under the second exceptions, that it is a promise to compensate wholly or in part a person who has already voluntarily done something for the promisor. So under these circumstances, even if the agreement is without consideration, it is not a void agreement. Now the third exception, when an agreement without consideration is not void, is that it is a promise made in writing and signed by the person to be charged therewith or by his agent generally or specifically authorized in that behalf to pay wholly or in part a debt of which the creditor might have enforced payment but for the law for the limitation of suits. So as per this exception, an agreement without consideration is not void if the agreement is a promise to pay certain debt of which the creditor might have enforced payment but for the law of the limitation. So for this we can look into illustration E under section 25. It goes like this: A owes B rupees 1000 but the debt is barred by the Limitation Act. A signs a written promise to pay B rupees 500 on account of the debt. This is a contract. So from this illustration we can see that here A owed certain money to B, but B could not enforce the payment under the debt as the debt was barred by limitation. So if A signs a written promise to pay B rupees 500 on account of the debt, this is a contract. So the agreement may be without consideration, but it is not void since it is a promise to pay certain debt of which the creditor might have enforced payment but for the law of the limitation of suits. Since the debt was barred by the limitation, the creditor could not enforce the payment, and the debtor, he makes a promise to pay the creditor certain amount of the debt. So and they enter into an agreement. The agreement is not void though it is without consideration. So as per section 25 of the Contract Act, an agreement without consideration is void, but an agreement without consideration is not void if it is in writing and registered, or is a promise to compensate for something done, or is a promise to pay a debt barred by limitation law. Now coming to section 26. Section 26, agreement in restraint of marriage void. Section 26 goes like this: every agreement in restraint of the marriage of any person other than a minor is void. So as per section 26, an agreement in restraint of marriage is void. Another example of void agreement is mentioned under section 27. Section 27, agreement in restraint of trade void. Every agreement by which anyone is restrained from exercising a lawful profession, trade or business of any kind is to that extent void. So as per section 27 of the Indian Contract Act, any agreement by which any person is restrained from trade or exercising a lawful profession or any business of any kind, that agreement will be declared void. Coming to section 28, it says that agreement in restraint of legal proceedings void. Section 28, agreements in restraint of legal proceedings is void. So as per section 28, every agreement by which any party to any contract is absolutely restricted from enforcing his rights under that contract, or any agreement which extinguishes the right of any party or discharges any party under an agreement from any liability, then that agreement is declared void under section 28 of the Indian Contract Act. So any agreement which restrains any legal proceedings is void under section 28 of the Contract Act. Now coming to section 29. Section 29 says agreements void for uncertainty. It goes like this: agreements the meaning of which is not certain or capable of being made certain are void. So if we look at the illustrations given under section 29, for example illustration A, it goes like this: A agrees to sell to B 100 tons of oil. There is nothing whatever to show what kind of oil was intended. The agreement is void for uncertainty. So the illustration says A and B enters into an agreement to sell 100 tons of oil, but the agreement nowhere mentions what kind of oil was intended to be sold under the agreement. So since it was not certain, it was totally uncertain as to the kind of oil that was to be sold under the contract, that was not certain, so the agreement is declared void for uncertainty. So agreements the meaning of which is not certain are void under the Indian Contract Act. Now section 30. Section 30 says agreements by way of wager void. It goes like this: agreements by way of wager are void, and no suit shall be brought for recovering anything alleged to be won on any wager or entrusted to any person to abide the result of any game or other uncertain event on which any wager is made. So section 30 of the Contract Act clearly mentions that any agreements by way of wager is void. So these were the agreements which are declared to be expressly declared to be void under the Indian Contract Act 1872. Now coming to voidable contracts. According to section 2I of the Indian Contract Act 1872, an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other, is a voidable contract. Thus, a voidable contract is the one which could be avoided by one of the parties to the contract at his option. So, voidable contracts are valid unless one of the parties has set it aside. If none of the parties sets the contract aside, then the contract remains a valid contract. However, if one of the parties to the contract sets aside the contract, then it becomes a voidable contract. Now, under what circumstances a party may wish to set aside the contract? This has been discussed under certain provisions of the Contract Act, which we will be discussing now. To begin with, we can look into section 19 of the Contract Act. As per section 19, when consent to an agreement is caused by coercion, fraud or misrepresentation, the agreement is a contract voidable at the option of the party whose consent was so caused. A party to a contract whose consent was caused by fraud or misrepresentation may, if he thinks fit, insist that the contract shall be performed and that he shall be put in the position in which he would have been if the representations made had been true. So, as per section 19 of the Contract Act, when the consent of any of the parties to an agreement has been obtained by coercion, fraud or misrepresentation, the agreement is a contract which is voidable at the option of the party whose consent was so obtained. That means if the consent of a party to the contract has been obtained by coercion, fraud or misrepresentation, then that very party can set aside the contract. Illustration A to section 19, it says A intending to deceive B falsely represents that 500 mounds of indigo are made annually at A's factory and thereby induces B to buy the factory. The contract is voidable at the option of B. So, from this illustration we can see that here A intending to deceive, that means that intention to deceive must be already there. So, A intending to deceive B, he falsely represents certain facts to B and then induces B to buy that factory from A. Now, since the consent of B has been obtained by misrepresentation or fraud, since the consent of B has been obtained in a wrong way here, so the contract is voidable at the option of B. Similarly, section 19A of the Contract Act says that when consent to an agreement is caused by undue influence, the agreement is a contract voidable at the option of the party whose consent was so caused. So, if the consent of the parties to the agreement has been obtained by undue influence, then the party whose consent has been so obtained can set aside the contract. This is section 19A. Next, section 53 of the Contract Act. Section 53 of the Contract Act also talks about voidable contract. Section 53 goes like this: when a contract contains reciprocal promises and one party to the contract prevents the other party from performing his promise, the contract becomes voidable at the option of the party so prevented, and he is entitled to compensation from the other party for any loss which he may sustain in consequences of the non-performance of the contract. So, basically, section 53 talks about non-performance of the contract. For example, if two parties enters into a contract and the performance of the contract is based or dependent on the performance of reciprocal promises by both the parties to the agreement, and if somehow one party prevents the other party from performing his part of the promise, then the party who has been so prevented from performing his part of the promise, his part of the agreement, can set aside the contract and he is entitled to compensation for any loss that he suffers due to the non-performance of the contract. This is section 53 of the Contract Act. Now coming to section 55. Section 55 talks about effect of failure to perform at fixed time in contract in which time is essential. Section 55 reads like this: when a party to a contract promises to do a certain thing at or before a specified time or certain things at or before specified times and fails to do any such thing at or before the specified time, the contract or so much of it as has not been performed becomes voidable at the option of the promisee if the intention of the parties was that time should be of the essence of the contract. So, section 55 talks about any contract in which time is the essence of performance of the contract. So, here suppose two parties enters into an agreement, and if one of the parties to that particular agreement promises to do certain thing at or before a specified time, then and if that particular party fails to perform that part of the contract before that fixed time is decided between the parties, then the other party may set aside the contract. So, these were the examples of voidable contracts under the Indian Contract Act. So, this was all about void agreements and voidable contracts under the Indian Contract Act. Thank you for listening, and in my next video, I will come up with another very important topic from the Indian Contract Act 1872. Thank you once again for listening, and please subscribe to my channel and do like, share my videos. Thank you.